Delta Sigma Theta Sorority Incorporated will be filming, recording, and photographing this event for use in Delta promotional videos, photography, advertisements, social media platforms, web pages, and other future Delta events as the case may be. Via continued participation in and by continuing to remain logged into this event, hereby acknowledges that participant may be photographed, filmed, or otherwise recorded while on the premises of the event. Grants Delta, its successors, assigns, and licensees irrevocable consent to include participants' name, likeness, photographic image, mannerisms, and voice or other recording in the production or for exploitation for any purpose whatsoever in any and all media now known or hereafter devised throughout the universe in perpetuity without compensation and or credit. Represents, warrants, and agrees that Delta holds and shall forever hold all display, publication, and ownership rights, licenses, and privileges to any and all media, whether in law or in equity, which may be ascertained, registered, or in any way utilized with respect thereto, and waives, releases, and transfer, as the case may be, any and all such rights, whether in law or equity, as may be necessary or required to effectuate Delta's establishment of ownership. Participant further agrees to abide by and comply with any and all terms of use and or additional participation rules as applicable and specified during relevant sections of the program and acknowledges, understands, and agrees that violation of such participation rules shall result in legal recourse and disciplinary action.
Good evening, everyone. My name is Renee Moore. On behalf of the Fairfax County Alumni Chapter President, Helene Fisher, and the members of the Financial Fortitude Committee, it is my pleasure to welcome and thank you for joining us this evening. All presentations are offered to assist you in building a strong financial foundation. Tonight, our topic will be Estate and Business Planning Reimagined. At this time, please give your attention to Soror Angelina McCarthy-Bryan, our Financial Fortitude Committee Coordinator and Moderator for the evening, who will introduce our guest speaker. Angelina?
Thank you so much, Soror Renee Moore. I appreciate that. Good evening, everybody. Thank you so much for joining us on this wonderful Friday. We hope you've had a great day, and we are so thankful to you because you could have been anywhere this evening, but you did not consider it robbery to come and join us tonight and get some great information to not only fill your mind, your spirit, but most importantly, to help you with your financial future, which is exciting. We have an amazing guest for you this evening, and we hope that you will take it all in. So grab your tablets, your pen, and good old paper, and write down, jot down, take as much information as you can. And as they say, don't just look at it, run with it, use it, and put it to good work. So first, tonight, we're going to take a little bit of a look back, as we like to do in our Financial Fortitude sessions. And obviously, it's something that you can come to. And we offer these wonderful sessions every so often, but quite a bit throughout our sorority year. So we're going to go ahead and take a look at this quick PowerPoint just to bring you to speed before I introduce our guest speaker by reading her bio for you this evening, and then we will hand it right on over to her. Right before that, we'll have a poll question, so get ready for that as well, so we can figure out if you're as they say, as informed as we hope you will be. So with that, I will go ahead and share my screen here. And then before you, you're going to see a quick PowerPoint presentation that we'll take a look at. And with that, as Renee shared this evening, we are talking about estate and business planning reimagined. And of course, we have Lily with us. And Lily, I just like to call her Lily because I don't want to mess up her beautiful last name, but it's Enkentor. So I hope I got that correct. Wonderful. She is our Esquire tonight, LLM, and she is the owner and managing partner of her firm. So again, this will be exciting for tonight. Taking a quick little look back, we wanted to share with you all a introductory session. We have this called the Building a Strong Financial Foundation. We have discussed principles of being able to create your own blueprint for your own successful financial future. With that, we have talked about generational wealth. We have brought with us our guest speakers, Douglas Eze and Eugene Mitchell. We have also brought estate planner Amy Griffin, who's actually been with us over the years. But tonight's session is a little bit different because not only are we going to discuss estate planning, but we're also discussing business planning as well. So this is very great for our business owners. We've looked at long-term care insurance that I have discussed. We've also shared with Jason Howell, who brought with us 7 strategies for transforming your finances. In addition to that, we have brought about the fundamentals again for the blueprint to get a greater understanding of where folks are. And we took an in-depth look at estate planning as well with Amy a few years ago. We did something that was pretty unique. We brought about a panel of financial professionals, which consisted of Eugene Mitchell, Amy Griffin, Jason Howell, Tremaine Wills, and myself to discuss closing the wealth gap. And this was a very well attended session because there was so much to speak about. And then there was a very much a hot topic, which was cryptocurrency. We even did a 101 session of understanding cryptocurrency even better, and that was with Ansela Ramsey. Then we did Closing the Wealth Gap Reimagined, where we brought, as you can see here, there were a total of 5 different chapters that came together to bring forth, in fact, 4 different chapters that came together to bring forth the Closing the Wealth Gap. We actually brought business professionals who discussed their businesses, their practices, and we had breakout rooms for our attendees as well, which was very well received in the community. Now, here is something that was a little bit of a shift. We asked ourselves the whys behind our financial decisions. This was a session that focused on not only why we do things, but the psychological reasonings of why we do things. So again, very powerful with Cavett Minor Kane. We brought about, now I tell you, when I'm looking at this is a wonderful flashback for us. We even brought estate investing and obtaining equity in your residential property with Olabakala Buki Dele, who discussed specifically how to do that and why to do that. This was such a well-received session that we brought back Melvin Landry Jr. and Blair Binder, who dug even deeper into the discussion about real estate, the whys, the hows, and what to do from an investment perspective. So that was a very well attended. Amy came back to give us an even more in-depth estate discussion. As you'll find, estate discussions go on and on and on. Why? Because they were so important and so many of us need that planning. We also brought about setbacks, so financial setbacks and how to overcome those. We brought attorney Eric Goodman. We brought Cherie Warwick, and we also had with us, again, panel discussion with Pamela Sams as a wealth manager. This was very well attended, and we discussed everything from bankruptcy all the way down to pitfalls and protection and assets in addition to wealth management. So if you're looking at this saying, I wish I had attended these sessions, then please continue to join us. Many of our panel guests are authors. So these are folks not only who are in the business, but they're in the business and they write books to educate and keep us going. That consisted of, just so I don't want to fail to make mention of Eugene Mitchell, Douglas Eze, and Douglas Eze has actually written a second book as well, and Jason Howell. And also Ansela Ramsey, she has also written a book regarding cryptocurrency and your journey. Cavett Minor Kane also wrote about the psychological aspect to our decisions when it comes to our mind and our money and how to thrive. And this is 10 steps to self-sufficiency. So with that and without further ado, this is an informational presentation. Please note that the individual situations can vary. Neither the information presented nor any opinion expressed constitutes a solicitation for the purchase or sale of any product, service, or specific security. Neither Fairfax County Alumni Chapter of Delta Sigma Theta Sorority Incorporated or the members of the Financial Fortitude Committee are endorsing any individual investment, product, or service discussed. Please consult with your financial advisor, financial services professional, tax, legal, or accounting professional before making any decisions. Again, Helene L. Fisher, President of the Fairfax County Alumni Chapter of Delta Sigma Theta Sorority Incorporated. Without further ado, we're going to take a quick look at something that we call the financial house. This is important because when you're thinking about your home, this is a financial home. So we talk about things like protection, accumulation, preservation, and estate planning comes right along with that. Even in your first level, which the first level of the home was protection, there you see your wills, power of attorneys, trusts, emergency funds, debt management, charitable continuance, health insurance, auto insurance, home insurance, disability income insurance, long-term care insurance, life insurance. Again, these are just to name a few. So this is why we have brought with us Lily to help us discuss this in a more in-depth way. And as you can see here with the home, this allows we look for, again, building up and understanding how to grow through things like your cash, your net worth, risk management, and that brings in estate planning, college funding, retirement planning, and wealth accumulation. So this is the most important slide. Most people don't plan to fail. They fail to plan. We don't want that to be you on this evening. So because of that, we bring about financial professionals who can share with us what more we can be doing and should be doing. So with Lily, Lily is, again, a partner with individuals, and she actually partners with individuals, families, and business owners in order to meet their estate and business planning goals. She helps clients address their vision and devise appropriate tax-efficient strategies. She is uniquely skilled in removing complexity so her clients can control and take control of their personal and business objectives. Now, what's amazing about Lily is that she has, of course, an amazing array of education and background behind her. Just to name a little bit here, she has gone to Georgetown Law. She's also gone to Seton Hall School of Law and Rutgers University as well. Her accolades is that with the National Bar Association, she has been the 40 Under 40 Award in 2017. And then not only that, she volunteers for the Junior League of Brooklyn. She was also the president there. Not the president. She was a general member from 2018 to present, and also the communications chair from 2020 to present. So what's exciting about all of this, again, of course, the National Bar Association from 2018 to present, and also co-chair with tax section from 2013 to 2016. Just to add a little more to that, the National Association of Black Accountants, again, she was part of the Education Committee from 2018 to present. So with that information, Lily comes to us with a wealth of knowledge. And so we really want to take this information in. And before I actually go into Lily speaking, I'm going to ask you all a quick poll question because we want to gauge where you are now and where you're going to end up. So please see before you our poll. I'm going to read the question and I will not give you the answer. We're going to see if you're listening. We're going to make sure that we've got the information here. So here's the question. What percentage of Black Americans do not have a will? Is it 50%, 70%, 25%, 10%? Take a moment and answer that question for us. We've got almost 40 folks on here, so we want to see almost that amount in responses. But this allows us to see where you think the number lies. Give you just a few more moments there before we close our poll. Please feel free to answer. And this is a fun part of the participation. Now, just a little bit of housekeeping. At the end of Lily's presentation, we are going to have lots of opportunities to answer your questions. Please, please do us a favor. Go right in the chat. Write your question down as we're going along. Don't wait to the end because you might forget your question. And we will have Elsie Daniels go through every question, and Lily has committed kindly to answering every question that comes across the screen. So don't allow your question to be missed. Now, as we look at it, we have about 5% say it's 50%, 81 of people say it's about 70%, 14% of the folks here say it's 25%. So no one believes it's 10%. So right now, 70% is in the lead. Let's see what you think about that. So without further ado, I'm just sharing the results here for you all to see that. I'm going to go ahead and stop sharing. And Lily, so the floor is all yours. Thank you so much.
Thank you. Thank you, Angelina. Thank you all for allowing me to participate in this wonderful series. I am extremely impressed by all the persons, not just the persons who've participated, but the energy, because I know what it takes to put on a series regarding financial literacy, estate planning, real estate planning. And so hats off to your entire organization, because it's a big deal to take the time to put together this type of information. Thank you again, Angelina, for allowing me to be here. Hi, everyone. My name is Lily Nkenshaw. I have been an estate and business planning attorney almost 2 decades. Yeah, like 17 years. I don't know how that happened, but here we are. And I love what I do. Just love it. It was the only class in law school that made any sense to me. And I grabbed that diploma and said, well, thank you very much. Now I know what I'm about to do. I don't know what the rest of y'all are doing, but I know what I'm about to do. And I have been doing it ever since for almost the past 2 decades. And so the purpose of today's presentation is to share with you what I have learned. I have worked with clients from Seattle to South Beach. So I've met the different people. I've met the different socioeconomic backgrounds. I've run into the different ethnic groups, religious groups, political groups, economic groups. I've met a lot of persons. And so my goal is to distill what I've learned and share it with all of you without anyone having to incur 6 figures of debt. So consider this my gift to you all. I have created Planning Looks Good on You. Why? It is how I feel about planning. It looks good on you and it makes you feel good. We plan so many other areas of our lives. We plan where we're going to live. We plan our outfits. We plan where our children will be educated. We plan our weddings and 21st and 50th and 10th wedding anniversaries. We plan it all. But we don't plan what happens to the people and the assets we care about. And we're busy accumulating. I have to get this title. I have to get this degree. I have to get this raise. I have to get this cost of living increase. And we're planning and we're strategizing and we are accumulating. But we forget to plan what happens to the people and the assets that we care about. We've accumulated a thing. We've led this big, beautiful life. Why don't we have a plan around that? And in my professional experience, there's 2 really big reasons why we don't plan. One, we don't think planning applies to us. Somebody somewhere got in our ear and said, you don't need to do that. That doesn't work for us, or that's for those people over there, excuse me. The second reason we don't plan is there is a portion of planning that involves talking about a time when you are not going to be here, and that makes a lot of people feel uncomfortable, which I can understand. I went through it with my own parents. As soon as I started practicing, maybe 2 years in, I reached out to my parents and said, let's get your estate plan together. And when I tell you, I've never been blocked so many times. My parents were not trying to hear it. They were bobbing and weaving that conversation at every point. I was maybe 6 years as an estate planning attorney. And I said, well, listen, you guys are making me look bad. Where is your plan? Where is your plan? I need you to have a plan, because it's not about the assets really, mom and dad. It's really about creating peace of mind for me and my siblings, because it's going to happen and someone is going to need to take the lead, and that someone is probably going to be me. I need you to do something to make that job easier for me. And once I started to massage and get them comfortable with the idea, they did it and were actually relieved. But I say all of that to say that's a big reason why people don't plan. I don't want to talk about a time when you won't be here, when I won't be here. I feel superstitious. I'm not trying to welcome, my passing. So let's not talk about it. Let's put our head in the sand. And I'm here to tell you that planning should feel empowering. Yes, there's a little part of it that's uncomfortable. I'm not going to sugarcoat that. But overall, it should be an empowering experience where you walk away feeling like, wow, I have a plan. Now, I don't give anyone the impression that they can control every single thing. We cannot control every single thing, but we can influence. So think of your plan as your opportunity to influence the people who you leave behind. It's your opportunity to influence the assets that you leave behind because you accumulated them, you worked hard for them. Why just let it fall to the wayside? So at the end of this presentation, you should walk away with, these are the reasons why I plan. These are some of the things I can do on my own. These are the things that I can hire someone to do. And these are the ways, the steps that I can take to avoid the common pitfalls. In my opinion, why are we creating a plan? We know why people don't. They're afraid to talk about a time when they are not here, and they also don't feel like it applies to them. But there are several reasons why we should. One, organize your goals. We all have a goal, even if we don't necessarily write it out and chart it and color code it in our perfectly coiffed calendar. We all have some form of a goal. But if it is not organized and it is not in writing, then it is a wish. It is a wish. There is this hopeful thinking that people will just know what I want them to do when I'm not here. But that's not how any of this works. I have a lot of skills, and talking to the dead is not one of them. So I cannot just assume what you would have wanted if it's not organized and in writing. And you going through the process of creating a plan, whether it's an estate or a business plan, allows you to get real with what's important to you and not have this fantasy idea. Secondly, control the narrative. Let me tell everyone something really quickly. Death and money changes family dynamics in 2 heartbeats. All the warm and fuzzies and all the so-and-so would never, and that's never going to happen to us. We just took a lovely family vacation 2 months ago. A lot of that shifts when money and or assets are involved and someone has passed away. All of a sudden, all of those kind of heavy feelings that have been pushed to the side, they are unearthed and they are right there on the kitchen table staring at you. And then people start misremembering. People start twisting the story. People start manipulating. People start going into a hole because they don't want to deal with the uncomfortable nature of what's happening. If you are the type of person who wants to avoid that, then creating a plan is for you because that allows you to control and influence the narrative. And then the last reason we plan is to manage your money. You've accumulated something. What happens to it when you're not here? Which reminds me, again, why people don't plan. This idea that it doesn't apply to me is very, very prevalent because most people think I have to have a bunch of money. I have to have multiple properties. I have to spend my summers in the Bahamas or the Hamptons or South Africa. And because I don't do any of that, estate planning is for me and I don't need to worry about it. I tell persons that you have the power to manage your money and your assets regardless of the value. Do not allow anyone to talk you out of your right to plan because it doesn't exceed a certain amount. Is there complex planning that I would do for someone who's wealthy, maybe worth more than $10 million? Absolutely. The planning that I would do for an Oprah Winfrey would be different from somebody else. But that doesn't mean both people don't have a right to plan. Oprah has a right to manage her money. You, Angelina, Lily, Beth, Rob, whoever, we all have a right to manage our money. We all have a right to control the narrative, and we all have a right to organize our goals. So do not think that estate planning is for those people over there who are considered wealthy. Estate planning is for everyone. Business planning is for everyone. If you are the type of person who cares about what happens to your people and what happens to your assets when you're no longer here, then you are a person who cares about or should care about estate planning. I've broken down planning into what I call the planning pyramid, because a lot of times people are not sure of where to start and how to maneuver the process. And because of that uncertainty, they stand still. I'm here to keep you moving. There are 3 ways. Any strategy that I or any attorney will create for you will fall within what I call the planning pyramid. The very top of the pyramid is operation of law. The middle is operation of contract, and the bottom, or the foundation, is operation of legacy. What is operation of law? That means there is either a state law or a federal law that tells us when an owner passes, what will happen to that owner's asset. No ifs, ands, or buts about it. It is not controlled by your will. It is not controlled by your trust. It is not controlled by a text message conversation or a contract or a handshake agreement. There is a law on the books that tells us exactly what happens. The best and easiest example is real estate. The title on your real estate is an example of operation of law, because that title tells us what happens to that property. So for instance, me and my husband own the home together. The title says jointly with rights of survivorship. Jointly with rights of survivorship means when one of us passes, the other person automatically is the 100% owner, no ifs, ands, or buts. I could have something in my will that says when I'm not here, I want my home to go to my father. But it doesn't matter what I said in the will, because the title is operation of law and it's at the top. So it trumps everything else. Titling is very important. And that's one form of estate planning that you all can engage in without hiring me or anyone. I always encourage people, review the title of your property. Just because you pay the mortgage, it doesn't mean you own the home. Just because you've been living there and you're the one who's keeping the roof on and the lights on, that doesn't mean you own it. The title is the only designation that matters. So for those of us who maybe married a spouse who owned a home before we met, and now we've been living there for so long, we kind of thought we owned it too. We don't. You don't. If you want to own it, then you need to put your name on the title, or you need your spouse to mention that it goes to you in your will, and we will get there. So operation of law refers to anything that has a federal or a state law that determines what happens to the asset. Operation of contract. I would say anything with a beneficiary is a contract. That is your 401k, your IRA, your SEPs, your any type of retirement plan, even your regular checking and savings accounts can have a beneficiary listed. And I think they should, because when you're no longer here, your accounts are frozen. Unless you have a co-owner or unless you have a beneficiary, that account is frozen, which could be problematic if it's your account that was being used to pay the mortgage. If it was your account that was being used to pay your child's tuition. Your family can't afford for the account to be frozen, because it puts them in the situation where now they have to come out of pocket and maybe they don't have it. And that's when we see a lot of disruption happen to our family. So not only are we mourning the loss of a loved one, but we're completely upended because the finances are frozen. Nobody knows where anything is. No one has access to anything. And so one of the ways I encourage all of you to minimize that is putting beneficiaries on every type of instrument that allows you to do so, including regular checking and regular savings.
Lily?
Yes.
Sorry to interrupt you. We cannot see your slides.
This whole time?
Yeah, we've just been looking at your beautiful face.
Ladies. Oh my gosh.
You were so captivating, right?
Oh,
So
no.
we were enjoying every second of
Do
it.
you see this?
That's okay.
No.
That's okay. You're just fine. We were just we were right with you. We've got lots of notes going on, right, ladies? We've got lots of and gentlemen.
Thank you.
Lots
But
of
do
notes.
you see my slides now?
No, not yet.
Okay. What about this?
No.
Am I sharing my screen?
Let's
I
see.
don't think so.
And do you want to just, oh, there you go.
There you
well,
are.
well,
Yeah,
well.
okay, wonderful.
Y'all should never let me go on for that long, okay? What about this?
Yes.
Perfect.
We're back on track. Y'all, thank you for your patience. Okay, I was at the planning pyramid, which is right here. So we did operation of law. We're talking about operation of contract. When you are thinking about adding beneficiaries to your assets, ask yourself 3 questions. Number 1, is there a beneficiary named? Number 2, is that beneficiary over the age of 18? I'm not a fan of minors being beneficiaries because the financial institution will not cut a check to someone who's not at least age 18. And 2, it puts your family in a situation where now we need to go to court to apply to be that minor's financial guardian. That takes time and it takes expense. That child could be your child, but that doesn't mean you are their financial guardian. Even parents need to apply to be their own child's financial guardian. And like I said, that takes time and money. And so I encourage all of us to not have minors as beneficiaries. And then the third question you're asking yourself when you're thinking of naming beneficiaries is this the right person? If they receive this money, will they be responsible? Are they on some type of income-based program where if they received too much money from me, it would actually disqualify them from their benefits? Are they potentially under the influence of someone who would not help them make wise decisions? So these are the questions that I'm asking if I'm in your shoes and I'm looking at adding beneficiaries. Is there a beneficiary listed? Is this person over the age of 18? And are they the right person for this asset? I remember when I started my firm about 4 years ago. So even though I've been doing this for almost 2 decades, my firm was birthed at the height of the pandemic. And I remember a husband calling me saying his wife had died and he was having a hard time accessing her 401k because the beneficiary listed was her former boyfriend. And is there anything he can do? And I had to be the bearer of bad news, which I never enjoy, that the beneficiary status is a contract and it trumps the fact that they are legally married. So unless, homeboy was about to share the money with you, you're not getting that money. And a little insider tip, nobody shares the money. Not ever. It'd have to be like the bestest sisters in the world. Outside of that, no one is sharing the money. So it's important to name the beneficiaries and make changes as your life changes. Lastly, we have the foundation, which is operation of legacy. So think of it like this. If something passes by operation of law, we know where it goes. Operation of contract, we know where it goes. Everything else is just hanging out. I don't know what to do with Angelina's car. I don't know what to do with Ruth's home because it's only in her name. I don't know what to do with your 3 minor children if you and your children's other parent have passed away and the children are still under age 18. You're a business owner, but you have no business documents that dictate what happens to the business when you're not here. I don't know what to do with any of that. So in order to capture and create a safety net, you need your legacy documents, which we will get into next. Let's get into the basics of our legacy documents. Firstly, the will. We'll move through this at a good clip and I'll answer questions at the end, only because I know we've had a lot of estate planning sessions and I want to make sure that we also speak about business planning. Your will is your crossing guard. Your will says this: everybody stop. My job is to get the assets from one owner to the next. Think of a crossing guard that stops the traffic and makes sure that your student crosses, or your child/student crosses the street. The crossing guard doesn't follow your child to school to make sure that they're listening, that they're not hungry, that they didn't skip class, that they're not bullying or being bullied. That's not the job. The job is just to get the student from one side to the other. That is what your will says. Your will says, this is my name. This is my family. These are the guardians for my minor children. Pay my debts, because our debts don't disappear just because we're no longer here. And whatever is left, give it to this person, that charity, this sorority, and we're done. The beneficiaries can do whatever they want to do with it. If they invest it and turn into the next Oprah, fantastic. If they waste it at the blackjack table, that's a game, right? I don't know anything about gambling. If they waste it in Vegas, that's their problem as well. So you want the will to control how the assets are going to be distributed, to provide guardians for your minor children, and to control the probate process. A lot of times people say, I heard probate's terrible. Don't have a will, put everything in your trust. You want to go through the probate process. You just want it to be as seamless as possible. And that is the intention of the will. You want the probate process because you get letters from the court. If I name Angelina the executor of my will and I say, Angelina, I trust you, I just do everything that I've listed here on these pages, that in and of itself does not give Angelina the authority. She literally needs to take the will to the courthouse and say, Lily has passed away. Here's her will. She's named me in to be in charge. No one is fighting me about this. Can I now receive my letters? Angelina will receive letters from the judge that says Angelina can do all the things in this will. She needs those letters from the court in order to distribute the assets in my will. And just as importantly, she needs the letters to close accounts, open accounts, and negotiate with my creditors. My creditors don't want my will. They want the letters that say that they have that Angelina has the legal authority to pay my debts. So you want to go through the probate process. You just want to minimize it and streamline it. And that's what your will does. If you do not have a will, then wherever you reside has statutory language that dictates what happens to your assets. If you're married with no children, everything goes to your spouse. If you're married with children, it's split usually 50-50 or 75-25 between your spouse and your children. No spouse, no children, then we start looking for parents, then we start looking for siblings, then we start looking for nieces and nephews, and so on and so forth. So if you don't have a plan, there is a state plan waiting for you, which may not be what you want it to be. And even if it is, it's just a longer, more hairy process. The second basic document is the power of attorney. The power of attorney is a very powerful, no pun intended, document, because what you are saying in this document is, if I am ever incapacitated, Alzheimer's, dementia, severe depression, some other form of mental illness, an accident, I'm in a coma, something has happened and I can no longer participate in making decisions for myself, I trust X to step into my shoes and make the best financial and or legal decisions they can. The power of attorney is for financial and legal decisions. This person can have access to your accounts. They can pay your bills. They can sign paperwork. They can run your business, assuming you check all the boxes and allow them broad authority. I'm of the school of thought to allow broad authority because you don't know what they will need to do for you in the future. There are some that limit it. Some clients prefer for it to be limited, and you can do that just with the understanding that if what you need them to do is outside of the scope, outside of the authority that you've granted, then they cannot do it. And if you're incapacitated and you can't adjust, then now we have to go to the court. And the whole purpose of the power of attorney is to avoid the hullabaloo of the court. So the power of attorney allows you to name someone who can make that decision. It is a living power. So once you are no longer living, there is no longer a power of attorney. And I encountered this with a client years ago who was all up in arms because the bank wasn't giving her access to her aunt's CDs, that her aunt named her as the power of attorney. I later learned that aunt had passed away, and that's why she didn't have access to the CDs. Once you pass away, that person no longer has any authority to engage with the financial or the legal decisions. Now their power has to shift to the will. The will gives people the authority after you've passed away. The power of attorney gives someone the authority while you are alive but incapacitated. And that's similar with your healthcare proxy. The healthcare proxy and the power of attorney are what I call your emergency documents. I've fallen and I can't get up. I need someone to come and help me. Your power of attorney comes and helps you manage your legal and financial. Your healthcare proxy person comes in and helps you manage your medical. They can make medical decisions for you. They can speak to your doctors. They can have access to your medical records because ordinarily HIPAA would not allow that. They can choose what facility, they can choose the treatment, they can choose the nursing home. They're stepping in and making the best medical decisions they possibly can, given the circumstances. So in my professional opinion, those are the three basic documents. You want your will to direct your assets, your power of attorney to name someone who can make legal and financial decisions for you, and your healthcare proxy to choose someone who can make medical decisions for you. Sometimes my clients go the extra mile and say, you know what, and usually it comes from bad experiences. They'll say, you know what, my grandfather was in the hospital and he wasn't doing too well and he didn't have brain function anymore and he just wasn't having a good quality of life, but my mom had a hard time letting him go, and I feel like we should have just allowed him to pass away naturally a lot sooner. It was just unnecessary for him to live like that in the hospital for all those months. I don't want that to happen to me. Lily, give me something that says if two doctors have looked at me and there is no cure, no surgery, no drug that is going to help me get better, and that I am going to die soon, meaning the doctor's giving me 2 weeks, 2 months, 6 months. If in that very narrow situation, that's what's happening, it's okay to allow me to pass away naturally. You don't have to say, try again, give me all the drugs, give me all the tubes. You can say, it's okay to allow me to pass away naturally. So sometimes people want that extra coverage and they add the living will to the healthcare proxy, the power of attorney, and the will. And it's up to you to decide if you want to do that. Living will can be very misleading because a lot of times people think the living will is the same as the will because they both have the word will in it, so it's understandable. But think of living will as end of life instructions, very narrow situations where a physician has said, I'm really sorry, there's nothing we can do. This person is going to pass away soon. That is your opportunity to say what you would want to happen in that situation. Now, trusts. I don't know what everyone's social media feed looks like, but mine is full of wealth and legacy and generational and home decor and a little nail inspiration as well. But a lot of legacy stuff. And I constantly hear, put your this in the trust, put your car in the trust, put your house in the trust, put your business in the trust, put your clothes in the trust. Everyone is acting like the trust is the next coming of Jesus. And I want to say that the trust is amazing. If you are choosing the right trust to do the right thing, it is amazing. But it is not a magic wand. It doesn't solve everything. This is when I use a trust. We start with the basics, the will, the power of attorney, the healthcare proxy, and the living will if you want to. I layered the revocable trust on top of that. If you tell me, you know what, Lily, I do want to make gifts, but I want to control how my beneficiary is going to receive the gift, and I want to control when they receive the gift. So it's not enough for me for my will to just move the asset from my name to my daughter's name and then we're done. No. I want my daughter to be 25 years old first. I want my daughter to graduate first. I want my daughter to use this money for postgraduate education or for her first home, or for her wedding, or for her startup business. I want to make sure that my child doesn't just have access to all of this all at once, and I accidentally spoil them and disencourage them from actually going after it and being productive citizens, right? So I want to control the when and the how. If you are concerned about controlling the when and the how, if you are concerned about keeping a particular asset in the family for as long as possible, or if you are concerned about the beneficiaries' creditors. So what if my daughter was sued because of the work that she does? What if my daughter has rental property and her tenants sue her? What if my daughter gets a divorce and her future ex-spouse wants what I've given her? If any of those are your concerns, then I layer the trust on top of the basic documents. It doesn't replace it. A lot of times people will ask me, well, if I have a trust, why do I need a will? Because they're two documents that speak to each other. The will is for you to go through the probate process simply so that you can get those letters we spoke about earlier. And then the trust has the robust, detailed, lifelong instructions. You can't put in your will, only give this to my daughter when she's age 25. That's not how the will is set up, but you can put it in the trust. So I always tell people we combine the two. I make a skinny will that basically just handles the basics and gets you through the court process as quickly as possible. And I create a fat, juicy trust that has all of the details. I want my favorite emerald ring to go to my niece. I want my favorite sorority to get this money to start a scholarship in my name. All of the juicy details I will put in the trust and the basics so that we can get through the probate process as quickly as possible. We'll go through the will. So they don't replace each other. People often say, don't I save taxes if I have a trust? And I always ask people, which taxes are you talking about? There's so many taxes: income taxes, capital gains taxes, real property taxes, estate taxes. Sometimes it feels like there's a tax on breathing. Which tax are you talking about? That will let me know which trust is the right trust. Most people, when they say it saves on taxes, are thinking income taxes and estate taxes. Putting your rental property in a trust does not save you on income taxes. If your tenants are paying you $1,700 a month, whether they're paying it to you directly or they're paying it to your trust, taxes still need to be paid on that $1,700. So your trust is not saving you from income taxes. People also think that the trust will prevent estate taxes. And there are trusts that can minimize your estate tax. That's called an irrevocable trust, which we won't get into today. But most people aren't subject to an estate tax. In order to be subject to an estate tax, you have to meet your state's definition of wealthy, or the federal government's definition of wealthy. Right now, the federal government considers a couple wealthy if combined you add all of their assets and it exceeds approximately $24 million. If that is not you, the federal government is not going to assess an estate tax. But some of us live in states that have their own number. I'm in New Jersey as of a month ago, and there is no estate tax in New Jersey. So I could be worth Bill Gates money and New Jersey will not assess a tax. The federal government will, because Bill Gates is well above 23 million, but New Jersey won't. I just moved here from Harlem, New York. New York has an estate tax. If you have assets in excess of about 6.9 million, New York considers you wealthy. So when people say, I don't want to pay estate tax, the first question you should ask is, does my state even have an estate tax? If it does have an estate tax, am I subject to that estate tax? And if the answer is no and no, or yes and no, then you don't have to worry about estate tax, and you don't have to get nervous about a trust that's saving on estate taxes because it doesn't apply to you. Let's get into some special considerations. Business owners. I work with business owners from startup all the way to someone called it like the life and the death, but I don't know if I really like that phrase, but from the startup to the transition. So people are coming to me and saying, I have a great business idea. I want to set up an LLC. Yes, I can go online and set it up myself, but I want to have an attorney cross the T's and dot the I's. I want my articles of incorporation. I want my operating agreement. I want all of the legal documents that I need to be official. I don't just want an LLC with an EIN number, which you can all do on your own, quite honestly. These are persons who are saying, I want the legal wraparound as well. And I live with that person through deal negotiations, reviewing contracts, reviewing leases, representing them in certain situations, all the way up to when I'm not here, this is what I want to happen to this business. Either I am selling it to someone, or I'm giving it to someone, or if I'm honest, I am the business. And if I'm not here, there is no business. So I don't have a plan to transition the business, Lily. What I want you to do is help me wind down the process, wind down the business, and we can have that conversation as well. So for those of you who are business owner, these are the things that I would keep in mind, because this is a conversation about planning looks good on you. That includes estate and business planning. If you are a business owner, make sure your entity is actually registered with your state. Sometimes you register it, but then you forget to stay on top of the annual or biannual filing requirements. So check to make sure your entity is actually operational. Get an EIN. It's free from the IRS website. Make sure you have your operating agreement, because even if you are the only owner of the business, you still want language that says, if I'm not here, this is what happens to the business. This is the second person in charge. This is the mission statement of the business. This is how much money I put into the business. All of these details exist in your operating agreement. It shouldn't just exist in your head. It shouldn't just exist in a conversation that you had with someone. It should exist in writing. So business owners, start with making sure your entity is registered with your state. Make sure that you are meeting the filing requirements. Make sure you have an EIN, and make sure at the very least you have an operating agreement with articles of incorporation. If you have a co-owner, make sure they have certificates of ownership. I'm going through this right now with a family that always thought husband and wife owned the business together. They had been operating it for 4 decades. Everybody knew this business as Mr. and Mrs. Jones's business. But we've dug through the files, and actually the only person who's on the certificate is Mr. Jones. Mrs. Jones never owned that business. I don't know if she thought she did. I can't speak to her because, again, that's not one of my gifts. But everyone thought she did, but there's no paperwork that says that she legally did. So for those of you who are co-owners of a business, especially if you owned it 100% and then you added a business partner, you didn't add a business partner if they don't have certificate of ownership and it's not reflected in the minutes. So make sure that you also have those types of documents as well. It's also important to note that there are certain contracts that you should have in your arsenal. I am really good with business owners with creating like a kit of documents. So for instance, if you told me, Lily, I have someone who does like celebrity makeup, right? And she was out there doing beautiful work, but winging it legally. I said, what contract do these people sign for you? What assurances do you have? Oh, I just show up on set and do my thing. Ma'am, stop doing that thing. Okay. Do the right thing, not that thing. So I create contracts that say, this is the contract you use for someone you're doing makeup with. This is the type of lease agreement you should have with your tenants. This is the type of contract you should have with your employees, including seasonal employees. These are the different contracts you should have in your arsenal so that when you are encountering different situations, you can say, this is the contract that I'm going to give to this person. I'll tweak it here and there, and I'll have Lily look at it to make sure I did the right thing. But at least I have a foundation. Just winging it and doing it for the love, no. No, exclamation mark. Lastly, what business owners should keep in mind is the valuation of your business, which is difficult when you've just started or you're not earning a lot of money yet, or maybe you don't have investors yet. But at some point, your business is going to be worth a dollar amount. And you can get that value in one of two ways. You can hire a formal business valuation company who will comb through the weeds and get you that number. Very detailed, very specific, and very expensive. The other way you can do it is have your CPA use these standard IRS formulas, run your business through the formula, and give you a roundabout number. There are some CPAs that do that regularly, and some don't do that at all. They only do tax preparation. So find a CPA who is in the practice of valuating businesses. So again, business owners, we're talking about making sure your entity is registered correctly, keeping your box or your suite of documents that you use in these various situations, and not just downloading it from document.com, lease.com, contract.com, because you don't know who drafted that. You don't know if the law has changed and you're looking at an old version. You don't know if it really pertains to you. And so it's good to have a relationship with an attorney who you can call up and say, Lily, this is what's happening. What type of document do I need? And then I or whomever you hire can create that for you and make that your new standard document. And then lastly, business owners, when it's time to talk about who's getting the business, are you giving it to your daughter? Or do you want her to have some sweat equity and for her to buy it? If she's going to buy it, then we need to get into valuation. How much does she buy it for? Where does the money come from? A lot of times people can't afford to just give their business away because they've built it, and that is supposed to be their source of retirement income, or at least a portion of their retirement income. So not many people that I work with just give their business away, which is why valuation becomes even more important, because I want to make sure that it's valued properly and you're getting your sweat equity back. Another consideration, Medicaid planning. Many of us are concerned for ourselves or for our aging relatives about Medicaid planning. I think my mom might need to go to a Medicaid run facility, but I don't want them to take her home or her cars or her savings and all of this. What do I do? In that situation, you need to engage in Medicaid trust planning, which you would get from someone who specializes in that, specifically someone who practices elder care. I do not practice elder care. That to me is a very nuanced type of beast that should be left to people who do that more than 50% of the time, not someone who whips up a Medicaid trust 2 or 3 times a year. No, I would go to someone who lives and breathes Medicaid trust, because it's so nuanced and so state specific that the wrong paragraph could throw it off. But Medicaid planning is important because without proper long-term care planning, which is where I lump Medicaid planning into, everything that you've built can be taken away in under a year, because homes like nursing homes and facilities and at-home care, all of those costs add up. And it would be a shame to build your wealth and build your assets for it to be swept away because you don't have any long-term care or Medicaid planning. The last special consideration are transnational planning. Some of us are really out here like, I have a home in Bermuda, I spend 6 months out of the year in South Africa, whatever the case may be. Those are persons who need transnational planning. Yes, I'm going to create your US document, but we need to make sure your US documents talk to your out of US documents, your foreign documents, excuse me. So if you're in South Africa, I need to get with someone in South Africa who does what I do so we can make sure these documents are talking to each other. That's transnational planning. It doesn't apply to everyone, of course, but if it applies to you, you want to speak with someone and tell them, I have these assets outside of the country, or I expect to receive assets out of the country. It's not uncommon for people to tell me, hey, my grandmother passed away and she left me a plot of land in the Bahamas. I think I saw it once when I was like a teenager, but I don't know what to do with it. Can you help me capture it? Because I do want to own it, but I don't know how to go about that process. So if that's you, let's have those types of conversations. And I'll also add this. Some of you may be thinking, I'm not ready to have this conversation for myself, but you know what? My mom, I have a feeling that I'm going to be financially caring for her. I have a feeling she might move into my home. I have a feeling I'm going to need to access her account so that I can pay for her bills. If that's the case, you should at least start having a conversation with your parents or your loved ones about their planning. That's absolutely important, because if it's going to fall on you, then you should absolutely have a plan that talks about how you're going to care for them. So you may not be ready for yourself, but start to get your loved ones ready, because if you're like me, you're the person that people are going to go to. So helping them get their plan actually makes things easier for you. I have a client who said, when I lost my dad, it was devastating. Me and my siblings were just, it was like a karate chop to our stomach. But what we didn't have to deal with was the commotion of him not having a plan. He gave us such peace of mind that we actually could just come together and mourn him, and not try to mourn him and look for documents, and not mourn him and stress at the courthouse. He gave us peace of mind. And so I encourage all of you to engage in planning for your own peace of mind and for the peace of mind for the other people that you're leaving behind. Don't think of legacy and planning as just something you do when you have money to distribute. Legacy and planning should also be about, what feeling do I want to leave behind? What habits do I want to encourage other people to adopt? This woman now has the habit of planning. Because her dad did such a great plan for her, she came to me because she wants her children to experience what she experienced, which is the peace of mind to just mourn a parent and not be frantic about getting their affairs in order. So planning looks good on you because it allows you to control the narrative. It allows you to manage your assets. It allows you to create peace of mind. It allows you to care for the people and the assets that you've been caring for your entire life. And it allows you to control the narrative. And the reason people don't do it is because they think it doesn't apply to them, or they're afraid to talk about a time when they won't be here. Don't be afraid. Let's talk. Let's change the narrative and make this an empowering conversation. Because if we don't, then we're going to look stressed like this lady here on the screen. She's like, what? What did you just say? Because there are common mistakes that we get into. One is titling. Assuming that your name is on the title, that your name is on the deed, is incorrect. Or if your name is on the title, the way it is titled could also be a problem. For instance, tenants in common means you own 50%, the other person owns 50%. So when you pass away, your 50% goes to, quote unquote, your family, and their 50% goes to, quote unquote, their family. That can be a headache. So if that's not what you intend, then you want to change it from tenants in common to rights of survivorship. Verbal understandings. It is not uncommon for people to tell me, I don't need a plan, Lily, because my children know what I want them to do. Ma'am, sir, that's not how any of this works. Verbal understandings go to the wayside when people are resentful, when people are angry, when people misremember, and when people suddenly want to be manipulative. Do not count on verbal understanding to get your estate plan done or your business plan. Outdated documents. Oh, you have a will, but it's so old, it was written on like tablets. You want to update your documents because your life has changed. You've moved, you've married, you've divorced, you've had another child, you've maybe unfortunately lost a child. You are all of a sudden super wealthy. You've left the country. Someone has left you an inheritance, and now you need to control that in your estate plan. Again, people come to me all the time and say, Grandma, Mom, aunt, uncle, godparent, sibling left me something and it's just sitting there. I never put it in my name. I don't know what to do with it. You need to put that inside of your documents. And if you don't have it in your documents, then your documents are outdated. Outdated beneficiaries. Back to the example before, this woman named her ex-boyfriend as her beneficiary and forgot. I'm assuming she forgot. Maybe she didn't forget, but I'm assuming she forgot to put her husband on it. How many of us, I'm raising my hand with you, had their parents as their beneficiaries or their siblings as their beneficiaries before they got married or before they had children? Go back and review that, because your marriage doesn't trump that beneficiary status. The fact that you have a child doesn't trump that beneficiary status. Not using an estate attorney. The reason I don't like these online boilerplate forms that you can find is because those software programs assume you know what you're doing. They assume you know what you need and that you're making the correct selection. But if you aren't sure and you make the incorrect selection, it doesn't work for you. The other reason I don't like it is because it doesn't allow you to build a relationship with someone like me who checks in every 2 to 3 years to say, what's going on with you? Is it time to update your documents? The software is not doing that. And then the other reason, a lot of people create the documents and they don't sign it. Or they signed it, but they didn't sign it in front of a notary. Or they signed it in front of a notary, but didn't have any witnesses. Or they had the wrong witnesses. So they went through the process, but they didn't complete it properly. That's why I'm not a big fan of that. No incapacity plan. So if I'm incapacitated, I don't have a power of attorney, I don't have a healthcare proxy, and now it's too late. Because once you're incapacitated, you don't have the ability to sign the documents. Now I have to go to the court and say, Michelle had a stroke. She can't read, she can't write, she doesn't know what's going on. Her bills are piling up. I need to help her, but she can't sign. Judge, given the circumstances, can you name me this person's guardian? That takes time and that takes money. That guardianship process is not going to cost you less than $7,500. A power of attorney will cost you anywhere between $1,000 and $1,500. I would rather you pay that and have the peace of mind than throw caution to the wind and come out of pocket $7,500 to $15,000. And on top of that, the time and energy that goes into that process. And then lastly, no life or disability insurance. This comes into play for those of us who have debts. If you don't have a plan right now to pay off the mortgage before you pass away or to pay off the student loans before you pass away, at least have a funding mechanism that can be used to pay it. Biggest example, homes. People love the idea of leaving their homes for their loved one. This is a great brownstone. We should keep it in the family. This is a great piece of property. We should keep it in the family. But if the beneficiaries don't have the money to keep up the property, how does that help them? They don't have mortgage money. They don't have property tax money. If the roof goes out and the garage door needs to be repaired and the bathroom started leaking, they would faint because of the expenses they would have to incur. So a lot of times people come to me and say, I know my dad wanted me to have this house, but one, I don't want the house. Two, I can't afford the house. So what do I do? So if your goal is to leave an asset that requires financial upkeep, I suggest having some form of funding mechanism that allows the beneficiary to actually upkeep. And life insurance is one of those ways that you can do that. That is planning looks good on you. I hope that we walk away with again, feeling empowered and understanding that estate planning is for everyone, even you. There are levels to estate planning. So even if you start at the basic level, that is still an excellent plan. You don't have to have homes in the Caribbean and overseas in order for you to have a plan. Planning looks good on you because it gives you peace of mind. It gives the people around you peace of mind. And my hope is whether you work with me or someone else, you start this process for yourself and for your loved ones. I can help those who are in New York, New Jersey, DC, Maryland, and Georgia. New York, New Jersey, DC, Maryland, and Georgia. If you're not in those states, I can maybe connect you with someone. I'm trying to keep a really good Rolodex of people across the country, and I've been getting a lot of good names, but at the very least, I'm licensed in New York, New Jersey, DC, Maryland, and Georgia. So I'm going to stop sharing my screen so I can see you all and then answer any questions you may have.
Wow, Lily. I mean, if we could just give you a round of applause, you have done a phenomenal
Thank
job
you.
sharing this information with us and making it plain so that we can pick up our tablets and
Oh,
run with it.
yes.
This is awesome. And for those folks, Lily shared she's got a Rolodex, and trust us, you know, we do as well, which is exciting because all the folks who've come to speak, we've got folks that are in Maryland, that folks that are in DC. So if you're in Virginia, so in case you're like, well, who can I talk to? We've had speakers come on in addition to Lily, who may be folks you want to connect with. So Lily, I will not take too much time because there are so many questions, and
Okay, let's go.
it's going to get exciting. For those folks who have not put their questions in the chat, this is your opportunity to do just that. And while we're doing that, we're going to pull up the poll one last time. Let's pull up that poll because we don't want to miss capturing this before we get into questions. That'll give you all a second to do that. And while we pull up that poll, we're going to ask you all that question one more time. Now, while we're thinking about that poll, I am going to put in here in our chat our evaluations link. Please, 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 we want you to tell us if you like sessions like this, if you want more sessions like this. Please do go into that. It will only take you a few minutes to complete, but it will help us to know if we're on track or not on track. So if we can go ahead and have our technology bring up that poll real quickly. And ladies, if you can, and gentlemen, if we have any on here, please go ahead and answer this question again. What percentage of Black Americans do not have a will? So let's answer this question. See if your response has changed. We give you a few more moments. We've only got about 8 folks who've responded to it. So let's keep it going. We got about 15 folks, 16, 19. Let's keep going. We've got about 44 of us on here. We were upwards of 50 here. So we're excited about that. And we're going to be ending the poll here shortly. We want to make sure we capture these responses. So we are still at 70% is the majority for folks. I'm going to end our poll. We've got about 80 folks who are sitting, 80% of the folks on this call tonight believe that it is at 70%. So I'm just sharing those results so you all can see. That's pretty awesome. And again, you ladies and gentlemen out there are very smart individuals, of course. And we know that because you actually got the answer. Majority of you got the answer correct. This is going to shock you, maybe, maybe not. More than 70% of Black Americans do not have a will. When actor Chadwick Boseman, you all may remember who he was. He played Wakanda in Wakanda. When he died, he didn't have a will. Neither did recording artists Prince and Aretha Franklin. Each time the news broke, there was surprise that such notable names hadn't made estate plans. Yet, estate planning isn't as common as experts argue it should be, particularly among Black Americans. In fact, it is noted that in 2020, Black Americans have about 25.9% have a will, which means the majority of us do not. And these statistics can be found. Again, we always like to share with you the information on where to get this. But this was a poll that was taken And the data came from CNBC with regard to this. So you can actually look up that data if you'd like. Now, in the meantime, I'm going to turn it over to our Sarah Elsie Daniels to answer or to ask the questions to Lily. And I will put the link in the chat for evaluations. Thank you again, Lily.
You're welcome.
Hi, Lily. How are you?
Hi, good. How are you? Thank you.
Doing all right. Thank you so much for your presentation. I learned some more things that I am going to use to twist my parents' arms to do what they need to do.
We got to stay on our parents. It took me a while, but I got them. I got them.
Yes, and that is actually our first question. Could you go in depth about how you got your parents to come around to estate planning? And is it a difficult conversation? It's a difficult conversation, so how did you get your family to listen?
A bit of humor because my mom said, "Are you trying to kill me?" And I said, "Kill you for what?" Are you trying to kill me? I was like, "No, Mom. Listen, point to the thing in your home that you think I'm trying to kill you for." So I had to infuse some humor and say, "Mom, this isn't about mom and dad. This isn't about your belongings. This is about keeping it organized. Do you think that I am the person that's going to step up and organize your affairs?" Well, yes. Why? Because you're capable. You've always been a smart, capable person, and you do this for a living. Okay, so if I do this for a living and I'm suggesting that you do it, why aren't you listening to me? Because I'm not dying anytime soon, was the response. And I said, I do not want you to die soon. I want you to just create a safety net. So when you're no longer here, I know what to do. So it was the safety net language and making it easier for me and my brothers that I kept harping on that finally eventually got them to do it. And I think, honestly, I might have had help from another family friend who just randomly said, "Oh, I did a will." And for my parents to hear that someone else in their own generation from the same cultural background was doing the same thing, that gave them extra push. So I kept harping on, this process is to make it easier for me to help you because, Mom, we are going to be mourning you. We are going to be devastated. Don't also put me in the position where I'm looking for your documents. And I had to constantly repeat that for 3 years. And then they finally did it. And then I paid for it. I'm sure that helped.
Thank you for that. Someone wants to know if there is a different power of attorney for medical decisions.
Yes. So in New York, we call the power of attorney is for financial and legal. And then the healthcare proxy is for medical decisions. There are some states that call them both a power of attorney. It will say power of attorney for financial and power of attorney for medical. So depending upon where you are, they might call it power of attorney, but just make that distinction. Or if you are in one of my states, we call it a healthcare proxy and a power of attorney. So they're doing different things. The power of attorney for financial, and then there's a power of attorney for medical. It's not all one document. You need to look at the title and make sure you have the right one you think you have.
I know in Virginia, the health one is a healthcare power of attorney.
Yep.
The next question is, what if you have a beneficiary for your assets, then you get married? Will all of the money go to the original beneficiary? Or will it get split 50-50 between your husband and the original beneficiary?
Everything goes to the beneficiaries. If you remember the planning pyramid, it's operation of law, operation of contract, and your estate planning documents. Operation of contract is in the middle. And so anything that falls underneath it, meaning including your marriage and all of that, it trumps that. So if your beneficiary says Stacy, Stacy is getting it. Period. It doesn't matter that you went and married Steve. Steve is not getting it. If you want Steve to get it, put his name as a beneficiary. Otherwise, it's going to Stacy, and Stacy is not giving that money to Steve. I can promise you that.
Under what conditions would you want to avoid probate?
Right. I don't want to avoid probate. And I know there are attorneys who differ. I'll say this, if you are in a jurisdiction where the court process is disgustingly painful, then I would want to avoid it. And by painful, I mean it's an extremely busy county and not enough judges, not enough clerks. People aren't moving at a good pace. It's going to take you at least a year to get through the process. If that is what's happening in your county, then I understand wanting to skip the probate process. But if that's not what's happening, I don't think you need to avoid probate. Probate really puts a shiny pink bow or shiny red bow on everything so that no one can say that it wasn't done properly. So I wouldn't avoid it unless you're telling me your county is just a nightmare.
Makes sense. Why is it beneficial to place a home and life insurance policy in a revocable trust? Specifically, how does doing so affect estate planning, probate avoidance, and the control over assets during one's lifetime? And what are potential downsides or considerations one should be aware of before making this decision?
So most persons will place a home in a trust so that it does not go through the probate process. Because what they are saying to me is, I want my children or whomever to get it immediately. I don't want them to go through the probate process and then get it. Even if the probate process in my county is easy breezy and everything is going to be done in 45 days, I don't even want that. I want the process to be private because anything that passes via trust is private. No one gets to see that you left your home to your daughter. No one gets to see that you left your collectibles to your son. A trust is a private document, whereas a will is public. If someone wanted to, they could go down to the local surrogate's office, and if they have your information, they can pull up your public will. So for people who don't want it to be known what they've given, and they want the beneficiaries to receive it right away, no court process, then they're placing their home inside of a revocable trust. They're also putting their life insurance in a trust if they're not comfortable with the beneficiary receiving the money all at once. So if you name, back to Stacy, if Stacy is the beneficiary of my $500,000 life insurance policy, the company is writing Stacy a $500,000 check, and no one's watching what she does with that money. If I want there to be checks and balances, then instead of giving the money to Stacy directly, I will say the trust is the beneficiary. The trust will get the $500,000, and the trust will give Stacy money at different times for different reasons at different stages so that she doesn't get the whole check at once. Those are why people put their home and their life insurance policy inside of a trust.
And are there any downsides to doing this?
You have to pay for a trust to be created, if you consider that a downside, but I don't.
Should rental properties be placed in an LLC? And if so, is an attorney required to do so? And if not, how does an individual place a property in an LLC?
So this is someone who wants to take my job. Is that what I'm hearing? It's all good. So yes, rental property should be in LLCs because the LLCs give you creditor protection. If a tenant sues you, they can only sue you for the value of the LLC. They cannot come after you personally. It creates a fence between yourself and whomever that tenant may be. So the LLC is good for that. And then the LLC is a business. And so if you've been paying attention, the tax code is business owner friendly, not W-2 friendly. So having an LLC that's actually making money allows you to take deductions and things of that nature. So yes, you want the LLC. Is it required? No. This is how you can do it on your own. Create your LLC, get in your state, or maybe not even in your state. Create the LLC, get the EIN. Your title on your property has your name. You need to go down to the records office where the county where the property is located and change the title to say the new owner is ABC LLC. It will no longer be Stacy Jones. It will be Jones LLC. You need to change the title on the deed. That is the only way that the LLC can actually own the property. So set up the LLC, get the EIN, change the title on the deed by going to your records office, completing their forms and paying their fees. And then it'll be inside the LLC. Some things to consider. If the property has a mortgage, you want to consult with the lender to make sure it's okay for you to move it to the LLC. Some lenders say you can do that, but you need to pay off the mortgage first. Some lenders say you can do that, but you need to refinance first. And if you have a great interest loan, you may not want to do that. So look to your lender to make sure it's okay to move it to the LLC. And then if there are any tax savings that you're getting from owning the property personally, consult with your CPA to see if any of that would be affected if you move it to an LLC. Great question.
So we should just hire an attorney.
I mean, you said it.
As an estate administrator, how do you get help with determining the amount to pay bequeaths, I think is what they're trying to say, in the will when payment has been delayed because no funds were provided and interest needs to be included in Virginia? And how does that, and then how do you close the estate? But you can take the in Virginia part out and just.
Okay, so the first part of the question, they're asking me how to pay money to the beneficiaries if there is no money?
How to pay bequests in the will. So I guess if you bequeath something to someone, how would that get paid if there are no funds?
It wouldn't.
Okay.
So if I have a will that says I leave $10,000 to Angelina, but after my executor pays my bills, I don't have $10,000, then there's nothing the executor can do. They're not going to come out of their personal pockets. They're not responsible for that. So if there's not enough money in the estate after the bills have been paid, then there's no money to distribute to the beneficiaries. This is why I don't encourage persons to leave specific amounts to people, unless you name someone the beneficiary of an account. To say, oh, I'm going to give you $20,000 when you don't really know if there's going to be $20,000 is a little risky. I would instead say, after my bills are paid, Angelina gets whatever's left, or Angelina gets 50%, or Angelina gets 25%. That way it's 25% of whatever there is, even if it's just $1. So short answer, the executor is not personally responsible for making sure that the beneficiaries get their money if there is no money. If there is no money, then there's nothing to give to the beneficiaries. And the beneficiaries can't sue the executor for that, unless the executor took the money.
That part.
Yeah.
You ladies are doing such a great job, and I don't want to interject. I just want to share that we are at the 8 o'clock hour, but we are not going to miss answering your questions. We just want you all to be aware. So we're going to end putting in questions in the chat so we can give enough time for Lily, who's graciously taking a few more minutes here to answer the questions for you all. But in the interim, please don't forget to complete the evaluation. I'm putting it again in the chat for you all. This is so helpful to us. You all do not know how helpful we take your feedback and we bring in the folks that you want us to share with you. So again, thank you all so much for staying on with us. I'll pass it back over to Elsie. Thank you.
Thank you. How long does the process take to create a will versus a living will?
The same amount of time. In my office, once you complete your intake form, which is the form I give you to answer certain questions. I can turn around a will, depending upon what's going on around here. I can turn those documents around in 3 to 4 weeks. But the crux of it is if the client answers the questions. Sometimes people are like, I'm ready to go. They've paid, they've signed, I'm their person. And then I say, answer these 20 questions. And it's like, they've disappeared because now it feels real and it starts to feel uncomfortable and they don't have answers to the questions. So assuming you have answers to the questions and you get it to your attorney, you can get your documents in a month or less. But if you're sitting on the questionnaire and you're thinking they're just going to whip it up based on what other clients have told them, then you won't get it in a timely fashion.
Thank you. Are there other trusts available for medical planning outside of a Medicaid trust?
No, I would recommend using a Medicaid trust. And by Medicaid trust, I mean you are saying, I want to move assets out of my name so that when I apply for Medicaid, they don't take my assets, because Medicaid is a needs-based program. You can't exceed a certain asset class and you can't exceed a certain income threshold. So people start giving their stuff away, but instead of like literally giving it to a child, they give it by putting it into an irrevocable Medicaid trust. So when Medicaid starts looking around for what you have, they cannot look at what you have inside the Medicaid trust. So you want it to be in a Medicaid trust because it has very specific Medicaid language that makes sure that not only have you given it away, but after you die, Medicaid can't come to your estate and try to reimburse itself using your assets, which is possible. So you want it to be in a Medicaid trust and not something else that pretends to be a Medicaid trust.
All right, that's really good to know. For people who say estate planning isn't for them because they don't believe they have enough money, what can people expect to pay at the beginning of estate planning? And how would you persuade someone of the benefit of estate planning who is on a fixed income?
The basics, I would say the will, on average, depending upon jurisdiction and the size of the firm and all of that, you should expect to pay anywhere between $1,500 and $2,500 for a will. Even if someone is on a fixed income, I would say I've run into attorneys who can split the payment up. If you can find someone who can do that, that would be beneficial. Or you can start to do some of the other estate planning that doesn't require you to pay anyone. So putting beneficiaries on your checking and savings accounts, I think, is a really good thing. And then there are states that have like a form power of attorney. So you can find the Virginia power of attorney. And even though this goes against what I said earlier, but this is just in those really small situations where people are just like, I have no money to hire anyone, then I would go get the form power of attorney, check the boxes that apply to you, get it signed and notarized. And so you don't have a will, but you have someone who can make decisions for you in the event you're incapacitated, and you have people who are going to get your money. And if you are the type of person who doesn't own property, you don't have minor children, you don't have a ton of debt, naming beneficiaries of your assets might solve a good chunk of your estate needs. So for those who are on a fixed income, I would say at least have a power of attorney and a healthcare proxy, which you can get from like your state, and at least add beneficiaries to your financial instruments.
Thank you for that.
Welcome.
Who is considered a wrong witness in front of a notary?
Oh, someone who's benefiting from your documents. So if your daughter's receiving all of it and she's also the witness, that won't work. So choose a disinterested party who has their faculties. I'll leave it at that.
I think you already answered this, but someone wants to know what's a reasonable cost for some services.
Yeah, power of attorney to will 1,500 to 2,500. Same thing with the power of attorney and healthcare proxy, which usually comes as a bundle. Trusts are going to be more. They, depending upon complexity, they can range from 2,500. For the revocable trust that we spoke about today, plan 2,500 to 3,500. For more complex trusts, plan $5,000 or more.
Great. Someone wants to know if your slides will be available after the presentation.
Miss Angelina said that they would.
All right. There are a lot of thank yous and amazing presentations.
Thank you. You're welcome.
There's another question that says, if there is not a will and no spouse, if there's not a will and the spouse passes away and the beneficiaries before they were married cashes out the funds in the checking and savings account before probate and the estate is settled, can someone petition that person for the funds back if bills of the deceased still need to be paid? And I'll stop there first because this question is really long.
No. If I understand the question correctly, before they were married, they had beneficiaries listed.
Mhm.
They never changed the beneficiaries to their spouse. Now they've passed away and the beneficiaries took the money. Can someone force the beneficiaries to give the money to the spouse to pay bills? No. Beneficiaries trump.
All right. And then there's another part to the question is also, can a person legally appoint a power of attorney to act on their behalf on financial issues if they are living and are now not competent? Oh, living now and competent, not incapacitated.
Yes, that's when you do it. You create the power of attorney now and the healthcare proxy now while you're alive and not incapacitated. You can't do it otherwise. How would
But
an incapacitated person sign the documents?
but I guess they're saying, if, like, let's say I am living, I've created the power of attorney, I'm in my right mind, I can do everything, but I've given you power in my power of attorney to sign documents on my behalf. Can
Right.
you use it while I'm still alive and in my—
Oh, okay. Yes, I can. Yes, I can. That's why I said earlier, great question, that this is a very powerful document because you have to choose wisely. You want to choose someone who's not going to do that. I'm talking to you. I see that you're competent. I'm not interested in signing your checks and taking money from your accounts and all of that. I know that I'm supposed to step in and help you when you need help. But you're alive and you're competent, so you don't need help. But yes, could I technically waive my power of attorney and say I want to have access to this account? Legally, I could, yes. Great question, yes. So choose wisely, and if people start to act really suspiciously, yank those powers.
And it can also be used for good. Let's say if you live on the other side of a country and you need to sign a document, they can sign it on your
Absolutely.
behalf.
I have a client who's like, I'm out of the country 3 months out of the year. I don't want to be bothered. I trust so and so to do this work for me. I'm not incompetent. I'm not incapacitated. I'm just not here. So you can absolutely do it for that reason as well.
Can you name a trust as a beneficiary of your accounts, like a banking or 401k?
Yes. Check with the 401k. There are some providers, some carriers that require retirement beneficiaries to be persons. So your first choice might have to be a person, but then your backup can be a trust. I would look into the carrier that has your 401k, but definitely everything else. Banking accounts, investment accounts, mutual funds, all the others, CDs.
Right. Can you elaborate more on the charitable trust?
I'm creating charitable trusts for people who are creating a series of gifts versus a one-time gift. If you tell me I want to give $25,000 to my church and we're done here, then I would just leave that in a will or maybe even give that gift during life. But if you're saying I have an income generating asset and I want the income from that asset to be used to fund my favorite charity, open a scholarship in my name, open a school in my name, then I'm creating a charitable trust and we're choosing a trustee who can manage the funds and make sure that it's being paid to the charity regularly and that the charity is using it in the intended way. So a charitable trust is something that I use for persons who want to have a prolonged giving strategy even after they're no longer here. It's not for, I wouldn't charge someone all of that money because that's a more complex trust. Now we're getting into $4,500, $5,500. I wouldn't charge someone that if they're just making a single gift to a charity.
All right. Thank you. Thank you so much for answering all the questions and taking your time, even past the 8 o'clock time that we
Oh,
had
you're
set.
welcome.
And if any other questions come in, would it be okay to send them to you?
Yes, absolutely.
All right. And I will hand it back to Angelina.
Wonderful. Thank you, ladies, so much. We want to thank our audience for your participation. Please feel free to leave your thank yous in the chat. We will share those with Lily so that she knows how impactful she was this evening. I'm going to thankfully, again, thank her for all of her efforts and our entire Financial Fortitude team. I'm going to turn this over to our VP, which is Sarah Regina Ware, and then in conclusion, our president, Helene Fisher.
Thank you, everyone. Thank you, Lily. Thank you, Angelina, and the Financial Fortitude Committee. We have gained some knowledge and a different perspective on estate planning. So thank you for taking the time to answer all the questions. I've learned something new. As much as I thought I knew much about estate planning, I was able to gain a different perspective and knowledge. So thank you, everyone, for participating. Stay tuned to our website and social media for future events. And I'll turn it over to our president, Helene Fisher.
So thank you for that. It's always hard to be last. The point is what they said, I say. Lily, thank you so much for your generosity and your time that you spent with us this evening. You were enlightening, you were humorous, but we understood what you had to say. And I believe that the 50 plus participants, excuse me, also appreciated you. And know the Fairfax County Alumni Chapter of Delta Sigma Theta appreciates you. All right, well, choked up here. You are so good, I'm choked up. Along with your great presentation, we also have other presentations from our Fortitude Fridays that are available on our chapter's website. You can go to www.fcacdsd.org to see our other presentations under events replay. So please go there. And Sarah, Angelina would not be happy if you don't fill out the evaluation. So please do that. And remember that we are always here to help you build a stronger financial foundation. So with all of that, thank you, everyone. Have a good night and happy Friday.
Thank you.
I'll drink some water now.
Great. Thank you so much for attending, everyone. We're going to keep our participants in and we'll let everybody exit. Have a great night.